Adjournment request, if any, from item number 1 to 6. From item number 7 to 19.
Yeah, please, your lordship. Lordship, I beg to mention for adjournment item 6.
You are for the,
Lordship,
you are for,
lordship, the engaged counsel is out of station.
You're appearing for whom? You're appearing for whom? Appearing for whom?
Petitioner.
last time we granted time, we were about to dismiss the petition. Madam took time, at that time some other counsel appeared and she took time for arguing the matter, preparing the matter further.
Lordship, actually, the engaged counsel out of station for his health issues.
We have fixed the date. Counsel to the-
Yeah.
So and so submitted that.
Oh, yes, it has.
Out of station, that may be at that. Let's start 3 weeks. 3 weeks. Yes.
From item number 7 to 19.
May it please, your lordship, with the consent of other side, I beg to mention item number 17, your lordship.
Yeah.
Yes, your lordship, I'm appearing for petitioner, your lordship.
So who is the-
Lordship.
From item number 20 to 26.
Yeah, please, your lordship. Lordship, I beg to mention, with the consent from the other side, I beg to mention item number 10, lordship. For
Yeah.
item.
10.
Yes, lordship. But the matter may be listed after 2 weeks.
Lordship's permission, item number 12, my lord. Will be taken up after 3 weeks, my lord.
Why?
So the issue in that petition was whether the science graduate teachers who were amalgamated from the primary schools to the high schools could be considered for headmasters. I had a talk today morning also. We are bringing about a change in the scheme and the rules, possibly to include them. We are on a positive note. We'll have to place it before the cabinet. We need some time for that. I had taken the consent of the petition.
Okay, Mr. Ahmedin, the concept appearing for the response, education department has submitted that. The state government is contemplating
Okay.
to redress the grievance of the grievance of the petitioners. Therefore, matter may continue enjoy. Just after 4 weeks.
Lordship. Lordship, with consent of other side, back to mention item number 15, 15. Matter may be adjourned for the lordship. Let's.
May I please, your lordship, I beg to mention item number 20, 21, 22, 24, and 25. I've taken the consent from the other side. Matter may be listed after 3 weeks.
Where Mr. Kyle?
Mr. Gale is out of station. He has gone to Meghalaya High Court.
20, 21, 22.
24 and 25.
Yes, yeah.
Much obliged.
Any other request?
Lordships, I beg to mention 2 connected writ appeals for urgent listing on Friday.
How's the urgency?
Lordship, this was an order under section 26 of the Competition Act. Pursuant to the order, Lordship, the investigation has been stalled. So Lordship, we filed the case much before the ensuing puja vacation, but it has not been listed.
Next week.
But I have a prayer for listing of a writ appeal, if possible on Friday. We have preferred the writ appeal on 23rd of October. There is some delay in filing the appeal.
some urgency on our part, the direction is to reinstate the,
If it has to be condoned, then only the.
that's true, that's
Can be heard.
that's true, that's true, Lord. If possible, kindly, on Friday, kindly take. Friday. Not, all right.
Daily list for orders, item 1 along with item 27.
Here, my lord, we have filed an affidavit yesterday, my lord. But thing is that the matter is pending before the CMO, my lord. File has been endorsed to the Chief Minister office, my lord. So may I pray some more time may be given so that I can apprise the court, my lord.
What about the,
It's regarding, my lord, this compliance of this order, my lord.
we want compliance and nothing else?
Yes, my lord, that I understand. That is why, my lord, file has been placed before the CMO, my lord.
Why CM?
There is a procedure, my lord, that is why, my lord. Because, my lord,
What proposal you have sent to the
Because-
CM?
because, my lord, there are subsequent developments which I have already been placed on record by an
We are
affidavit.
not going to consider.
That
we
is-
have already
that-
made
that-
it clear.
Yes, that is why, my lord, because that was a cabinet decision. That is why it is placed before the CMO, my lord. So some 1 week time may be given so that
Have you filed any application seeking for the time?
no, my lord.
Then why the containers are not present here? Why the containers are not present? See the last order sheet.
Yes, my lord.
Have you filed any affidavit?
Yes, affidavit I have filed.
Where is
Affidavit,
that?
it is good. Yesterday I have filed, my lord.
You're not supposed to do it. এখন ইন্টারভেনিং অ্যাপ্লিকেশন কিছু পয়সা কপি এক্সট্রা কপি এটা দেশ
Intervening?
মানে মানে কি কি হৈছে ইহঁতে মানে অকল দুটা ক্ষেত্ৰতে কমপ্লাই কৰিম বুলি কৈছে বা এটা নকয় সেইবিলাক মাতি নি সিহঁতক মোক গালি চালি দিছোঁ সিহঁতে ভয়ে খাইছে গোটেই ট্ৰেন্সফাৰ কৰি কিনে এইবিলাক কৰে সেই অফিচাৰকেইটা নুশুনে ন লনো বুজাইছিলোঁ
This. Again, same affidavit,
Yes, well, they have, in fact, they have
again the same affidavit.
same instruction has been given to me, my lord. So I have just, that's why I have filed the affidavit because there was a direction from this honorable court. I have filed the affidavit. I've informed them, then it is the files that they have placed the file before the CM office on the thereafter, my lord.
Well, we are not at all concerned. Call them at two. Call them at. On 28th, 2024. This
Yeah.
board granted last opportunity to the respondents to file their response to the notice issued by this board on 23/9/2024. It is to be noticed that on 23/9/2024, this board
কপিটো এটা কপি দিছোঁ
has taken note of the filed on behalf of the container number 1 and has specifically observed that while additional affidavit, the respondent number 1 has attempted to contest the contempt petition by touching the merits of the case. It is further specifically observed that while exercising contempt jurisdiction, this court cannot go into the merits of the case. And after recording prima facie satisfaction to the effect that the respondents are guilty of willful disobedience of the orders and direction passed by this court, has issued notices to the contenders to submit their response to the said notice. On 28/10/2024. Taking into consideration the above facts, last opportunity was granted to the respondents to file their response to the contempt notice issued to them, with a caution that failing which the respondents shall have to remain present before this court personally today. Full stop. Then it counsel appearing for the contenders has submitted that in response to in 28, in response to the opportunity granted to the contenders on 28/10/2024, the respondent number one has filed an additional affidavit. The copy of the said additional affidavit is supplied to us. We have gone through the affidavit filed on behalf of the respondent number one yesterday. And it is surprising that the same or almost same arguments have been made in the affidavit, which has been made in the earlier affidavit, which we have taken into consideration on 23/9/2024. We have already disapproved the attempt on the part of the contenders to contest the contempt petition on merits of the case. This reflects the audacity on the part of the respondent number one and the other respondents, that how they are flouting the orders passed by this court. Taking into consideration the above facts and circumstances of the case, we have left with no choice except to direct the respondents to remain present before this court personally at 2 p.m. today itself.
Obliged.
I will pick up this matter at 2 p.m.
Item number 2.
May it please your lord, in this matter, I have appeared for the respondent number one.
The respondent number 6 has not been served.
My lord, reserving this
Reserve the
Instruction to appear on behalf of the state.
Respondent number 6. This is complete.
I have already appeared in this case, my lord. Earlier occasion for 7/8.
Okay. Mr. So-and-so put in, as per the office report, notices issued to the respondent number 6 remain unserved. However, Mr. So-and-so put in appearance on behalf of the respondent number 6. Service upon all the respondents is now complete. Yes. Is this matter for admission. When?
After a week,
After 3 weeks, enter the order, it may continue till next day. Interim order shall remain in current till next.
Item 3,
Wait, please, your lord. Lordship, the service office note says that the service is awaited, lordship, the neither ED card nor answer.
15.
Lordship, actually it ought to have been 5 to 15,
5 to
lordship. 1 to 4 had been the official respondent. Lordship, may I be allowed to take the steps through respondent number 4, lords? Because most of the person has been posted at a different postings. Meanwhile, so lordship, it would be difficult to trace out the present place of posting as well.
What do you suggest?
Lordship, through respondent number 4, lordship.
Who is respondent number?
The personal department, lordship. The secretary, government of Assam, personal
But
department.
this notice has not been returned with
ED
this is not found on.
Lordship, nothing has written. In fact, Lordship, the neither ED card nor unserved notice has not been received. Lordship, we are under an impression, Lordship.
Claiming that they are posted somewhere else.
Somewhere.
But that is not. With appearing for the respondent number 4. You're appearing for the respondent number 4. You provide in the details regarding the present posting of the unserved respondents 1 to 5 to 15.
My lord.
Okay. Notice to the respondent number 5 to 15 on 31st of July 2024 remain unserved till date. Stop. When it concept for the applicant that submitted that there is a possibility that the respondent number 5 to 15 who are the government servants may be posted somewhere else. The may be posted on a place other than the place which has been mentioned in the cause title of the writ appeal. Stop. Taking into consideration the fact that the respondent number 5 to 15 are the government servants, we request the concept for the respondent number 4 to provide details regarding the present posting of the respondent number 5 to 15 to the counsel for the petitioner within a period of 1 week. On receiving such details, the counsel for the appellant may file fresh requisition for issuance of notice to the respondent number 5 to 15 to registered AD and Dusty. The notice, on furnishing the said details, on furnishing the requisites, notices be issued to the respondent number 5 to 15, returnable 4 weeks thereafter.
Highly obliged.
Deeply under.
item 4,
Wait, please, allow. By your lordship's last order, lordship directed the respondents to file an affidavit clarifying their stand.
My lord, I have received the instruction, my lord. 7 days I need time, my lord, to file my affidavit,
7 days.
my lord.
And when it concept, if this office note is a response, By the Panchayat Raj and Rural Department. Yeah, when council, preparing for the Panchayat Raj and Rural Department raise a week's time frame, clarifying the extent of the respondent with regard to the grounds taken by the appellant in the present appeal. Start.
Highly obliged.
My learned friend gave an undertaking till now date, they have complied, we hope they will do so, Miller.
Yes, yes,
That will remain.
yes, yes. Obliged.
Item 5,
I please your lordship, I have taken the steps on 17/9/2024. Service report is awaited.
Await return of notice of the whole respondent for 3 more weeks.
for admission, item 7,
Made a loss to come. Yes, we are appearing.
Lordship, can you say page 20? This is the notification issued by the BTC authority.
Page 20.
20. It's a notification, Lordship. Neither it's a statute nor a rule under 309, Lordship. I don't know why this matter has come before the division matter.
But
Pardon?
the London Single Judge has made already observation that it amounts to amending the rules of 1886, regulations 1886.
No, the regulation has not been amended. It's only a clarification, Lordship.
He's saying, madam, it should not have come to division bench. That is, I think, his submission, no?
So my objection will consider. Should notice. On behalf of the respondent number,
I'm appearing for 3, 4, 5, and 6.
4, 5, and 6, and what about the others? And who's appearing on? You are a metal bridge. So and so is appearing on behalf of the appearing on behalf of the respondent number 2. Sir, Nayak put in appearance on behalf of the respondent number 1, 2, 2, 2.
No, Lordship, I'm for 3, 4, 5, and 6.
3, 4, 5, and 6.
Yes.
Let notices be issued to the remaining respondents. Who registered a EDM Dasti returnable 4 weeks thereafter.
Obliged, close.
item number 8,
Wait, please, your lordship. বুক লিস্টখন দিলা না?
Yeah, give me that. Yes.
Lordship, my humble submission is that, Lordship, while the allegations are raised regarding land, mining, forest permit, and sand mining, then fund diversion, timber cutting, etc., including coal, sandalwood, cement factory, way bridge. Till now, all these are very wild allegations, Lordship. And at paragraph 6, they have stated very clearly, the petitioners have not made any representation to the respondent authorities in this regard.
Your precise preliminary objection is to the effect that they have not made any representation.
Number one, and this is a sixth schedule area. So paragraph 14 of the sixth schedule very clearly says the governor can appoint a commission at any point if a complaint is raised.
That can't be strictly in sense, you can't say it is a preliminary objection. But so far as regarding your objection that since they have not filed any
Yes, Lordship.
representation,
Yes,
that PIL is not maintainable, that is not reflecting. This 10G only says that if any representation is filed, you mention it. If they have specifically said we have not filed any representation.
that is one. But on the other hand, Lordship, the alternate remedy is available. I'll place a Supreme Court judgment on this, very recent judgment.
Yes.
Paragraph 31 of my lord, very recent judgment. That is here. 2022 Supreme Court Online SC 1541. Paragraph 31, Lordship. The last page of it, second last page of that compilation. We are not, may I read it, Lordship?
Yes.
We are not for a moment saying that the people who occupy high offices should not be investigated, but for a high court to take cognizance of the matter on these generalized submissions, which do not even make prima facie satisfaction of the court, is nothing but an abuse of the process of the court. The non-disclosure of the credentials of the petitioner and the past efforts made for similar relief as it has been mandated under rules 2010 further discredits this petition. The petitioner in the PIL did not go with clean hands before the High Court. In our opinion, such a petitioner liable to be dismissed at the threshold itself. If the petitioner has a genuine reason to pursue the matter, he has his remedies available under the Companies Act or under other provisions of law, where he can apprise the relevant authorities of the misdeed of the directors or promoters of the companies. But on generalized averments, which are not but mere allegations at this stage, the court cannot become a forum to investigate the alleged acts of misdeeds against the high constitutional authorities. It is not proper for the High Court to entertain a PL which is based on mere allegations and half-baked truths, and that too at the hand of a person who has not been fully able to satisfy these credentials or has come to the court with unclean hands. So my humble submission is the facts. This is relating to mining in Jharkhand. Okay.
Not a.
Contribution percentage tax on this. Aku dismiss as a one. Petition to file को देते हैं inform करना पड़ता है तो जहाँ पर witness को अपने inform student और हम student और बापे civil student और application लेता थी system माने offense के तो जो majority पाए ठीक है कौन अरे देखिए मैम 70 बबल है
Yes.
Paragraph 5, 12, and 13, very relevantly. Same thing happened in Sikkim also, and this case is happening in Jharkhand. They have lot of other alternative remedies. Straightway, they cannot approach the Honorable High Court to initiate an investigation, Lordship. And on top of that, Lordship, I think Lordship has already perused paragraph 5, 12, and 13. Otherwise, I am going to place it. As well as paragraph 14 of the 6th schedule. Because the other day, one of the major political party regarding allotment of some land in the same 6th schedule area in Umrangshu lodged a complaint before the governor. Hardly 10 days ago, Lordship. They have also allegations against land allotment to a particular cement factory. Paragraph 14 says, appointment of commission to inquire into and report on administration of autonomous districts and autonomous councils. So NC Hills falls under this 6th schedule area. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous districts and autonomous regions in the state, including matters related specified in C, D, E, and F. That we are not concerned. Up to here, it is sufficient, Lordship. So if they have any allegations regarding the administration of the 6th schedule area of NC Hills district or Dima Hasao district, Lordship, they can straight away approach His Excellency, this is a constitutional authority. A constitutional power has been given. They cannot bypass it straight away. If His Excellency Governor refuses to accept their complaint, then they definitely have this option of coming here. And in other cases also of Karbi Anglong, Lordship was pleased to direct them to approve the Principal Secretary of Karbi Anglong Autonomous, another 6th schedule area. That judgment also I am placing. Series of judgments of Karbi Anglong. They cannot straight away come, Lordship. So my humble submission is that, and if explanation of paras 14 of 6th schedule is given in a judgment of this honorable courts, a division bench judgment of 2011 to GLT page 80. Alphonse D. Sangma versus Royna D. Sangma. This is regarding dissolution of one of the autonomous council in Garo Hills. Paragraph 31. Paragraph 14 equips the governor of the concerned state in which the autonomous district or the autonomous region is located to appoint a commission.
Para 31.
31.
Paragraph 14.
14. It is explanation of this paragraph. Paragraph 14 equips the governor of the concerned state in which the autonomous district or the autonomous region is located to appoint a commission to examine and report in any matter specified by him relating to the administration thereof, including those specified in so-and-so of para 1, or to inquire into and report from time to time on such administration generally, and in particular on inter alia the administration of the laws, rules and regulations made under by the district and regional council. The governor is empowered in this regard to define the procedure to be followed by the commission. The report of such commission will be recommended by the governor with respect thereto to be laid before the legislature of the state by the minister concerned, together with an explanatory memorandum regarding the action proposed to be taken by the government of the state. If there is any violation of the royalties of the forest, or regarding land allotment, or regarding cutting of trees, everything comes under this, Lordship. So this is a constitutional provision which cannot be bypassed in my humble submission. The door of the Honorable High Court will open if this action is not properly taken, if they have any grievance at this stage. And on top of that, the identity of the petitioner is not disclosed, which is very vital of the Honorable Supreme Court judgments, Lordship. If Lordship is pleased to come to paragraph 5, he is not disclosing his identity. 3 persons. Now here it is said the petitioner. There are 3 petitioners, how it can be a single person here. The petitioner is a socially conscious individual, and this petition is being filed by the petitioner in public interest, and he is representing the voice of all other people of the locality who are aggrieved by the action of the respondent authorities. The petitioner further state that the petitioners have the means to pay the cost if imposed so and so. So now if Lordship is pleased to look at the petitioners, there are 3 in numbers: Rajiv Langthasa, Himan Kemprai, and Ronel Langthasa. Whether these are political persons, these are other vested interest persons, we do not know anything. This very general statement that he is a socially conscious individual. Now it is not also an individual. Individuals it should have been. So this is a major flaw. The identity is very crucial. Maybe these are all political adversaries. If we look at the history and legacy of the litigations of PIL, of Karbi Anglong as well as Dima Hasao, it is always a political battle fight through PILs. Either at the time of election or just after the election, when they cannot win the battle of ballots. These are all frivolous, politically motivated petition. If they disclose their identity, the cat will be out of the bag.
Yes.
So at this stage, my Lordship, this is my humble submission. 2 judgments I would like to place of this honorable court also. PIL 7 of 2019, Mohan Rongvi, paragraph 13. We are not saying that they can be unsuited, only that they cannot come. Let them approach, Lordship. If there is real illegalities, Lordship, it has to be rectified. Paragraph 13, last 3 lines. The PIL was disposed of by the order dated 8/3/2020 by taking note that the stand of the KSC authorities that the projects have been duly completed. That is the stand there. Liberty was, however, granted to the writ petitioners to approach the principal secretary of Karbi Anglong Autonomous Council if any fresh evidence becomes available to suggest that the projects have not been completed. And also, paragraph 20. Insofar as the complaint lodged by the petitioner before the Chief Minister's vigilance cells and the alleged inaction of the authorities in respect thereof is concerned, remedy is available to the petitioner under the Code of Criminal Procedure. The Honorable Supreme Court also said the same thing. As such, the grievance of the petitioner, if any, in respect thereof would have been suitably redressed by the taking recourse to the procedure prescribed under the law. The writ petitioner, however, failed to avail such alternative legal remedies before approaching this court by filing the present PIL. For the reasons stated above, we are of the view that no merit in this PIL. So this is one of the ground of dismissal of the PIL. And this is Lordship's order of very recent time, Lordship. It was of 8/8/2024, 8th of August. And the councils are all more or less same. And another judgment, Lordship, PIL 1/2023. Maybe. Here also, this honorable court was pleased to direct the petitioner to approach the governor. Lordship was a part of this judgment. M. Bhagavati Learned Counsel appearing for the petitioner on instruction has submitted that the petitioner wants to withdraw these PIL petitions. However, he seeks liberty for the petitioner to approach the Honorable Governor of the state of Assam, come Chancellor of the Assam Agriculture University, Jorhat, for redressal of his grievances, essentially raised in these PIL petitions. Learned Counsel for the respondent have no objections if the petitioner is permitted to withdraw these petitions. PIL with the liberty as paid. In view above, PILs are dismissed on withdrawal with
That was
liberty.
on, request.
Request because it was about to be dismissed, then they took the liberty to withdraw. It was about to be dismissed.
We don't know about that.
That is where the instruction was taken. So today also I'm not objecting. Let them go. And if they do not get proper remedy there, they can always come. And we are not shying away from the grievances, the allegations. Allegations are very wild, but we have replied to everything. These are all politically motivated without, and if Lordship is pleased to look at the annexers, no homework was done at all. Some work orders were annexed only. They did not want to find out what exactly is happening. Work orders has to be issued for any contractual work. Work order itself indicates that there was a tender process. So this is my humble submission. In this petition has no merit at all, Lordship. In that view of the matter, Lordship may be pleased to dismiss this petition at this stage. Let them approach the appropriate authority. They have lot of appropriate authority. One is His Excellency under paragraph 14. They can also lodge criminal cases. They can also lodge vigilance cases. They can also go to the police station. And if they are not happy, then CRPC is there. Now the new law has come. They can approach the local magistrate. Straightway, this is not the code for initiation of any kind of investigation. This is my humble submission.
My lord, first I will place that judgment of the Supreme Court, my lord, pursuant to which the High Courts were directed to frame rules. That is, my lord, 2010, 3 SCC 402. My lord will kindly lay down the law in this case, my lord. We'll be very happy, my lord. If there is a uniform guideline is given, then my lord, yes, no, I'll place it, my lord.
Guideline, in fact, this.
No, my lord, no, my lord, my learned friend every time says everything is politically motivated. He always sees politics in everything.
Okay, without.
No,
ignoring
I'm
that-
not casting any personal aspersion. What I'm
ignoring
saying
that-
is, my lord,
Ignoring that aspect of the matter.
Yes.
Even without, before this, entertaining this PI also, when we go through this PI.
yes, lordship must be satisfied about our bona fides.
Bona fides, apart from bona fide, in fact, the allegations leveled in this PI are so wide and so vague. In fact, now you just come to this.
My lord, which person in NC Hills will dare to come up with X, Y, and Z,
Not
knowing the, my lord, the nature of the CM?
Sir,
They're afraid of him.
apart from that.
He was a militant.
Now, kindly, the individual permit holders with close connection to the CM of the country given challan for significantly cheaper rate.
My lord, his wife has been made a party,
Sir,
CM's wife.
KNT Enterprises, you have made a mention about that.
Yes.
What is this KNT Enterprises?
No, my lord, in
It's a
Assam also,
company on-
people have not filed many petitions fearing. They are coming, now people are coming out. In Assam also, I'm saying.
I fully object to this,
What
lordship.
object? It is not Hindi
This is not
cinema.
a banana republic, lordship.
It is not Hindi cinema.
Sir,
I
kindly
object.
consider-
What nonsense?
Mr.
No, my
Chaudhary,
lord, okay.
kindly consider-
Anyway, my lord will
These
kindly come to the,
allegations-
my
these
lord come to
allegations-
the judgment.
Your simply close connections with the CM are getting this, he is running this stone quarries, he is running this toll nakas. These allegations have to be substantiated.
Yes,
sir.
yes. We'll try to do that, my lord. Please come to the legal position. I'll come to the facts also.
Fine.
Para 178. We must abundantly, page number 460. We must abundantly make it clear that we are not discouraging public interest litigation in any manner. What we are trying to curb is the misuse and abuse. According to us, this is a very important branch, and in a large number of PIL petitions, significant directions have been given by the courts for improving the ecology and environment, and direction helped in preservation of forest, wildlife, marine life, etc. It is the bounden duty and obligation of the court to encourage genuine bona fide public interest petitions and pass directions and orders in public interest, which are in consonance with Constitution and the laws. The public interest litigation, which has been in existence in our country for more than 4 decades, has a glorious record. This court and the high courts, by their judicial creativity and craftsmanship, have passed a number of directions in a large public interest in consonance with the inherent spirit of the Constitution. The conditions of the marginalized and vulnerable sections of the society have significantly improved on account of court's direction in PIL. So it is in this background, my lord, these directions were issued. Now, one of the direction was that we should ideally file a representation to the authority before we approach your lordships. That has been incorporated in Rule 10(1) of the Guwahati High Court rules. Now, my lord, kindly appreciate one thing. Which authority in NC Hills will accept a complaint against the CM, my lord?
The governor, sir.
My lord?
Governor.
No, I'll come to that. My lord, that para 14 is for different purpose. I'll pay Supreme Court judgment also. Para 14 has got nothing to do with investigation of an allegation, my lord. Para 14 is something to do with.
He can appoint a commission.
Well, otherwise, it can be. I'm not saying
This
it's.
is of the report of the commission, the further proceedings.
No, my
can
lord.
be drawn.
My understanding is, subject to what your lordships may say, para 14 operates in a different field altogether. In fact, in Bare's case, my lord, this point was considered. I'll place that judgment. I brought it. Now, kindly see, my lord, in our considered view, now it has become imperative to streamline the PIL. It is in that end in view, my lord. I think they're referring to 6. Court should ensure that petition which involves larger public interest, gravity and urgency must give priority over. No. Come to goal. Legal partner content, we should be satisfied.
Para 5, sir. The
Court should be
should
fully satisfied that substantial public interest is involved before entertaining the petition. All right. And-
Four also.
Lord, court should be prima facie satisfied regarding correctness of the content of the petition before entertaining appeal. Yes, yes. Now, my lord, what I'm trying to submit for lordship's kind consideration is High Court rules are framed under Article 225 of the Constitution. Article 225 starts with the word subject to the provisions of this Constitution, meaning thereby, my lord, subject to Article 226. And 226, we all know, my lord, it's a constituent provision. It's the basic structure of the Constitution. I don't think, my lord, a High Court rule framed under 225
Not at all.
can.
Not at all.
Ah.
Yes,
Yes.
certainly.
Yes.
Here in these rules also,
Yes.
it is specifically made clear.
Now,
It can be relaxed.
yes,
These, there
precisely, my lord.
can be relaxed.
Yes.
That's right.
In an appropriate case, it
But
can be relaxed.
Ultimately,
Hmm.
these allegations
Huh.
which has been leveled in this PIL petition,
Hmm.
we don't find that these allegations are sufficient to initiate the process. That these allegations are so vague. In fact, everywhere, the contractors are paying so and so, these contractors are their persons and therefore they will, sir, how to relate these connections, sir? Simply say they are running he is running several quarries.
My lord,
Sir, it's
before-
very,
my lord,
vague
before going to the facts-
To all this.
Madam, before going to the facts, if I may place para 14, I'll come to the facts, my lord.
Sir.
Kindly permit me to place para 14 of the sixth schedule, on which reliance has been
Yes,
placed by the other side.
yes,
I'll come to the facts.
Yes.
Now, please come to para 14.
What?
Appointment of commission to inquire into and report on administration of autonomous district and autonomous region. My lord, my humble understanding is para 14 is a provision whereby, my lord, to streamline or to make the autonomous council more effective or to find out the inherent defects in the working of the system, my lord, there could be a commission and, my lord, based on the recommendation of the commission, it will be placed in the assembly and the authority will take note of it. Now, we are before your lordships with a complaint that there are rampant corruption going on.
That we understand, sir. The
Yes.
tenor of the public interest, this petition.
Yes.
Yes, we understand. Where are the details, sir?
Now let us see, my
Where
lord.
are the details?
So, my lord, my humble submission is neither
Now,
para rule 10(1) nor para
apart from
14
that,
would
sir,
come in
apart
the
from
way
that,
of entertaining the
first-
petition.
the first requirement is.
Yes,
The court must be satisfied.
yes,
Then only we can proceed further.
yes,
The court must be satisfied.
precise.
Now,
That there can be no doubt about it, my lord. Now, my lord, will kindly see, please come to page 36,
36 of.
the petition, my lord.
Fine.
No. Now, this is a permission given by the Forest Department, my lord, with reference to the letter cited above. You are hereby asked to issue permit to Rupam Carrying Spa of Haflong for collection of so-and-so, boulder from Jatinga River from so-and-so up to so-and-so, under Harangzao range on payment of royalty and GST as per so-and-so, so-and-so. No extraction collection shall be allowed 50 meters from the outer. Now, my lord, the royalty fixed is 200 rupees per CM, my lord. Now, what is being charged? 350. Page number
Person
41, my lord.
agreed, how you agree that the person who is to pay, he
But
is.
this money is going to the pocket of these respondents.
Sir, where is that proof that these money over and above the 200 rupees,
Hmm.
300, 150 rupees going to the pocket of the person? Sir, where is that proof? From where we find out, sir? Sir,
And,
that-
okay,
yes,
okay.
sir.
Then please come to page 43, my lord.
Sir.
Now, KT Enterprise is the respondent number 15's entity.
Fine.
Now they are being permitted to take free, no imposition.
That may be for that KT Enterprises should be intended as party, sir.
I think has been made. Yes, respondent 15.
Respondent 15 only.
Yes.
The Getty Enterprises. Getty Enterprises is a firm, partnership firm. It's a company. What is it?
It's a farm, my lord, of which respondent number 15 is the. If your lordship wants better particulars, we can come up with this, my lord.
Sir, in fact, we have pointed out simply only.
My lord,
this.
I am also
Now,
conscious.
Yes, sir.
My
Para
lord,
number 9.
I am also conscious of the fact, my lord, people are afraid to come up with the allegations.
Para number 9.
9, my
The
lord.
petitioner begs to say that CM controls 4 entry tax gates, Lima, Assam, so and so, so and so, and
Para, my lord.
19.
1, I'm sorry. Yes.
Page 27.
Petitioner begs to that CM controls the 4 entry tax gates of Dima Hassan, namely so and so, where he collects significant illegal amount of money. In this regard, it is stated that there is a rate fixed by council for entry of varying vehicles carrying goods and materials into district. However, a huge amount of money is illegally charged, which is over and above the genuine rate fixed by the council, and none of such vehicles are permitted to enter district without paying additional illegal money known as Gunda tax. The petitioner further states,
How to substantiate these allegations only simply because he is collecting from so and so, so this is known as Gunda tax, and therefore you should investigate. Sir, there must be some.
no, my lord, my humble
These
submission
allegations-
was in a PIL, perhaps we cannot produce all the
That's
materials,
why
we can
only-
only give it.
That's why only now this judgment of 2022.
No, no, 2020 judgment, with all respect, my lord, this is absolutely in a different factual context.
Sir, this is kindly para 30. Sir.
Para 31, precisely.
Three,
Yes,
30,
yes.
30, 30.
If your lordship wants better particulars, you will file an additional affidavit.
Thank you.
Kundu. Now, in this case, apparently there was earlier a PIL which was dismissed, which was not disclosed.
Here, that one of the ground on which this court has non-prepared.
331, my lord.
Sir,
Yes.
3030. Now let us see. What are the nature and allegations which have been made by the petitioner in the PIL file before the
32.
Jharkhand High Court? The petitioner alleges that the one of the respondents
yes.
is the present chief.
Now let us see what are the nature of allegations which have been made by the petitioner in the PIL filed before the Jharkhand High Court. Petitioner alleges that one of the respondents, who is the present Chief Minister of Jharkhand, has amassed a huge wealth by corrupt means by abusing his position as Chief Minister and has invested his money in about 32 companies, of which description has been given. The petitioner then gives detail of these companies as to who are the directors, etc. Respondent or his relatives are not the directors in the company. But then the petitioner states that he has information that he has been siphoning of this money and investigating this shell companies through one Ravi Kejriwal, who is allegedly a close associate of the chief minister. The allegation of the respondent of money laundering through shell companies has not been supplemented by any kind of concrete evidence. It has been stated that these persons are connected, close aides, or related to the chief minister. Further, none of the companies have been made a party to the present PIL before the Jharkhand High Court. Thus, an order is sought from the High Court to direct Enforcement Directorate to investigate these so-called shell companies without even making the companies a party in the proceedings. It is also admitted fact that in relation to the present 2PL, no FIR complaint has been filed with the police or any authority executing the grievance, and these petitions have been filed before the High Court without availing the statutory remedies.
Even in that petition, some details were there. Here, those details are not even there.
No, here, Milo, those companies, sale companies were not made parties,
No, sir,
and the
that is one of
directors
the-
were not
That
named.
is one of the
No,
points.
please come to 31, Milo.
What precisely we
No,
want to, we want to impress upon. Kindly consider even though there were details, directors' names were also there, but despite that, the Supreme Court has said that these details are not sufficient.
Lordship will kindly appreciate, yes, I do admit, my lord, people are not, I mean, they do not have the courage to, my lord, come up with the
Para
facts.
number 20.
That is the
Para
reason
number-
why, my lord,
Sir, para number 20.
of this judgment, my lord.
This PI.
Yes. Petitioner for
You said
several appointments in
vacant
vacant posts and council without publishing an advertisement. My lord,
Illegal.
okay.
Why these persons have not been made party, sir?
My lord will kindly permit, now I'll come to it. Please permit me to place para 31 of the judgment. My lord. Please come to para 31, which is perhaps the most important para in the judgment.
Yeah.
We are not for a moment saying that people who occupy high office should not be investigated, but for a high court to take cognizance of the matter on this generalized submission, which do not even make prima facie satisfaction of the court, is nothing but an abuse of the process of the court. The non-disclosure of the credential of the petitioner and past effort made for similar relief, as it has been mandated under the rules of 2010, further discourages this petition. The petitioner in the PL did not go with clean hands before the High Court. In our view, such a petition was liable to be dismissed at the threshold itself. If the petitioner has a genuine reason to pursue the matter, he has remedies available under the Companies Act or under provisions of law, where he can apprise the relevant authorities of the misdeeds of the directors of the promoters of the company. But generalized abatement, which are nothing but mere allegation at this stage, the court cannot become a forum to investigate the alleged act of misdeeds against the constitutional authorities. It was not proper for the High Court to enter in a PL which is based on mere allegation and half-baked truth, that too at the hands of a person who has not been able to fully satisfy his credential and has come to the court with unclean hands. Lordship, was this gentleman, my lord? He was a prosecution witness in Shibu Soren's case.
His father was prosecution.
His father of the chief minister.
His father was the prosecution witness. This person was.
Gautam Sharma.
Whatever.
No, my lord.
Apart from that, sir, he is all these allegations.
My lord will kindly permit me to place para 10. Please come to para 10.
Yes.
Please inquire about this, my lord. This is very important. The petitioner also raises concern regarding financial anomalies and diversion of government fund within NCHSE. The petitioner states that Assam state government had decided to transfer the entitlement grants and the single head of account to NHSE and thereby enhance the discretionary power of the chief executive member of the council. In this regard, it is stated that state-owned priority development fund is a scheme of the government of Assam, and NCHSE is allotted fund under SOPD scheme every year, and various works such as construction and supply work under numerous departments are carried out every year by utilizing such fund. The formal work order of such works under SOPD were issued to contractors. However, payment against such works are not paid by the NCHSE. In spite of several representations being filed by the contractor, the anomalies, particularly the financial anomalies of such works are under SOPD has not been regularized. Be it pertinent to mention herein that CM of NHSE, by using his discretionary power, has been using such fund for his own benefit and thereby public works are hampered. Once Sri so-and-so filed an application under RTI before the respondent number 13, that is executive engineer and so-and-so, seeking information pertaining to details of works and supply undertaken under SOPD and local fund during the year so-and-so. And in reply to such application, the executive engineer White later dated 1/6/24 surprisingly stated that no work and supply were taken up under SOPD and local fund during 19 to 23. In the said letter dated 1/6/24, in reply to such RTI query seeking photocopy of the administrative approval of SOPD and local fund during the year 2019-23, it was stated that such administrative approval does not arise. Petitioner humbly states that petitioner has collected various work orders issued to the contractor for works under SOPD during the period. Under such facts and circumstances, RTI reply, which contradicts the actual facts, clearly proves that CM of NCHSE is using the government fund under SOPD scheme as well as other local fund in a sly and confidential manner for his own gain.
Everything is fine. What you have said in the earlier part,
Huh.
reply which contradicts actual fact, clearly CM of the NHSE is using government fund under scheme for his own benefit. Own gain, sir, how will come to this?
Because he has discretionary power to allot that money.
It's very vague.
No, my lord, will I kindly seek a response from the government on this at least, my lord. It's a very serious matter, my lord. Well, I know our limitations, my lord. People- No, kindly see, my lord.
Allegations are, yes, allegations maybe, but not, neither here nor there, simply said. What we are saying in general terms, के साहब वो बहुत पैसे खा गया, ये कर गया, ये government वाले सारे ऐसे ही करते हैं, ये करते हैं. These are the allegations of such type.
My lord will kindly come to page,
Can't issue a PA.
no, kindly come to page 44, my lord.
Yes.
Now, where these funds have gone, my lord? If work orders were not issued, then the money has gone from the state government. A request for information under Right to Information Act. Name of the work and supply taken up under SOPD and local funds during the year so and so. Now kindly come to my lord, page 47, the reply.
Yes.
My lord, the reply is at page 47.
Yeah.
Reply to your request for information under Right to Information Act. Name of the work and supply taken under SOPD and local fund during the year so and so. No work and supply taken under SOPD and local fund during 1920. Name of the contractor and suppliers allotted duty does not arise. So I regret to inform you, there was no such work order, supply order, so and so. Now, fact of the matter is, my lord, under the SOPD, money has gone to the, NHSE. So where this money has gone, my lord?
Maybe in other words.
No, that's what. Well, at least this calls for a response, my lord. Even without issuing notice, also lordship can ask for an response from the government on this. Kindly come to page 50, my lord, 49.
Yes.
Page, page 49.
Sir.
To so and so, construction of approach road and so and so. With reference to the subject cited above, I am to say that above mentioned work under special grant to NCHSC
Now,
Aflong.
please clarify, this special grant is something else or it is this state
SOPD.
policy development, priority development?
No, my lord, that's a state government's own fund. That money doesn't come from center or somewhere. That's
State
state.
owned priority development SODP.
Yes,
Your allegation is that they informed us that under this SODP, no work was sanctioned or no supply has taken place.
yes, yes.
Here the information says with refer the above work under special grant to NHSC Aflong for the year which
Well,
special grant
special,
it is, sir?
special grant they refer to SOPD, my lord. Subject to correction, my lord. That's what we're told.
That's why only, sir, we are everything you are seeking clarification. Let them clarify. Without, sir, these problems.
No, lordship will appreciate, my lord. In a PIL, perhaps we cannot come up with, the materials which your lordship should normally expect.
That's why.
That is there, my lord. That I'll not say no.
That's why only, sir, this Balwant Singh all judgment is there, sir.
Yes. No.
Remain this.
No, that is there, my lord. End of the day, it is your lordship's satisfaction, which is a must. Even before issuing notice, that I'm for a moment, I'm not saying no, my lord. That is absolutely correct. But question is, lordship will also appreciate one aspect of the matter. My lord, this hills areas, my lord, people are not in a position to, everything is, anyway, my lord, time will say whether we came with materials or not.
Ultimately, we have to take into consideration whether in.
No, certainly, my lord. It's not my contention that the only thing is, my lord, at times it is difficult. My lord.
There are some self-restraint, to say that.
Or if your lordship so feels, that is also a lordship's discretion, my lord. If your lordship feels that we can come up with some more better materials, we can do within a week's time if your lordship gives. Of course, lordship has devoted much of time. I can leave it to your lordship, my lord.
That option is also available, but if you want, you withdraw it with liberty to approach the competent authority such as governor or whatever.
Lordship will give me, my lord, 7 days time. Let me also talk to these people, my lord. And my lord, whether we approach the governor, whether we, or lordship will also give us the liberty. If necessary, we can come up with better particulars. Yes.
The SPL petitioners.
My submission would be lordship.
Essentially, just a minute. Yes, essentially, with the prayer to direct the respondents to constitute an inquiry committee or SIT to investigate and probe into the rampant corruption and other illegal activities within the district of Dima Hasao, particularly in the forest department of North Kachar Hills Autonomous Council. Preliminary objection regarding the maintainability of the PIL. Of this PIL petition has been raised on behalf of the secretary, on behalf of the forest department, as well as another department is,
I am product council,
as well
lordship.
as the principal secretary to the NH, what's the name? NCHAC, NCHAC, which stop.
Well, with your lordship's kind permissions, can I take leave?
After hearing the learned counsel for the parties at length in respect of the preliminary objections raised on behalf of the respective respondents, we are of the view that the preliminary objections raised on behalf of the respondents has merit to stop. At this stage, learned counsel appearing for the Mr. Ken Chaudhary and the senior counsel appearing for the petitioners raise a week's time to complete his instructions, whether the petitioners are willing to withdraw this writ appeal, this PIL petition to supply better particulars, or then to approach the appropriate forum for redressal of grievances, or to supply better particulars in support of the PIL petition. List after a week.
Deeply obliged.
Item 9.
May I please, your lordship? May I please? May I please, your lordship?
May I please, your lordship? I have approached this honorable court against the order of the cat lordship. That is an
The
extra,
order of the cat is dated.
that lordship, an extra and 21 February 2019 lordship.
So why after 5 years?
Lordship, I have mentioned in para 20 of this petition lordship.
There are 28,
Para 20 lordship of our petition lordship.
20, yeah.
Lordship, actually after receiving the cat's order, the petitioner become upset lordship, mentally upset.
For whom? Why? Why?
Because
upset?
he lost his employment lordship. Lost employment and
Employment, you lost your employment in, you lost your employment
in 2019 lordship.
no, no, no.
No, that is lordship and extra B lordship.
In which year your services were terminated?
Lordship, 2012 lordship.
2012.
12.
Services were terminated in 2012. Removed from service in year 2012.
Lordship, that is
Uh,
13 lordship.
On a lighter note, sir, I don't know. Your client has lost his.
No, I
so-
was
but
placed on put of
You are
duty.
not aware with the facts, and it seems that you lost your.
Yeah, left us one. Handled to.
He was removed from the services in the year 2014,
14 lordship.
and the cat has passed the judgment in the year 2019.
2019 lordship.
So for 2014 to 2019, he was okay. But after 2019, he lost his whatever the
No,
balance and everything. And therefore now he has approached this court after 6 years.
no, he has already approached the honorable court and
To whom?
proceeding was going on lordship at that stage.
Which proceedings were going on?
And Central Administrative Tribunal lordship at that very particular yes
What's the
lordship.
reason, and is it a good ground that since you have been acquitted from the criminal charges, now the order passed under in the disciplinary proceedings is liable to be interfered? Is this a good ground for interference of that?
Lordship, actually, I was also acquitted lordship in
Whatever it may
CFS.
be, acquittal may be a different thing. That is on the basis of benefit of doubt.
See.
Not a clear cut acquittal. Even though if you are acquitted, those proceedings which were initiated in the disciplinary proceedings can be treated as a null and void, or
Lordship, actually, Lordship, our charges is also not specific, Lordship. Prosecution could not specify what amount the petitioner has already defaulted, Lordship.
what was the finding of the disciplinary authority?
Mixer H, Lordship. Mixer H. Lordship, may kindly look at Annexure H, page 65, Lordship. Article 1 and Article 2 shows different amount of defalcation as stipulated, Lordship.
PRR.
Even FIR also shows different amount, Lordship. Really, Lordship, he's very hailing from very economics, poor economic background, Lordship.
Yeah.
Yes.
Lordship, may kindly look Article 1. That is, amount has been shown as 2,20,000
Sir,
as
you come to
defaulted
page
amount.
88.
Lordship,
Come to page 88.
Lordship,
Observations and findings.
Lordship.
Okay.
Defalcation of any amount, whether or less or more. That is Lordship.
Now, para number 5.
Further, the representation dated 5/7/2014 submitted by Sequelin is not satisfactory tenable at law at all. Sequelin may have not submitted any substantial point of defense in his representation dated so. In para 9 of this said representation, he stated that his offense in the case was owing to inevitable financial and household problem, which the Sequelin must stated during the oral inquiry of the case also.
Next.
Sequelin had deposited more than the defrauded amount voluntarily, which depicts his good motive, but it is also an established fact that he had cheated the innocent customers of this department, betrayed the trust of the public, and maligned the image of India Post. Therefore, he is not a fit person for retention in the department.
So, your admission before the inquiry, before the disciplinary authority, that you have misappropriated money on account of inevitable financial and household problems. And now since you have deposited the money also more than that,
No,
that will not exonerate you.
on the basis of the instruction, Lordship, of the respondent number 5, I have deposited the 2,70,000, Lordship.
Why deposited, sir, when you have not embezzled the amount? Why you have deposited?
Before placing the put of my from duty, Lordship, I had already deposited, Lordship. Thereafter, Lordship, charges frame, Lordship. Entire amount, Lordship, I have deposited, Lordship. Even, Lordship, prosecution also paid what amount?
Before I got, before.
Yes.
Lordship. I was also not given the proper training, Lordship. That is reflected, Lordship.
What
For
training?
for maintaining the accounts, Lordship. I have already mentioned in our various petition, in appeal petition also, Lordship.
When you were appointed in the service, when you were appointed in the postal department?
2009, Lordship.
Appointment?
2009, Lordship.
And
Annexure A, Lordship.
and in 2012, you indulged in those activities.
So, you is procedural.
Annexure D itself speaks, Lordship. Annexure D, Lordship. The charge we have committed as LS committed, Lordship. from 11/8/2009 to 28/5/2012, Lordship. Annexure D, Lordship. That is reflected in Article 1, Annexure 2, Article 1, Lordship. During my service period. So many accounts were they've taken, but only few accounts they've taken into consideration, Lordship. And out of 7 witnesses, 3 witnesses were examined. I have not given the chance to cross-examine other witnesses also. Lordship.
That's all.
Lordship may kindly look at our FIR also. The defalcation amount
Why
is
we are-
very Lordship.
We are not here examining the criminal case, man.
Statement also recorded, Lordship, behind our back, Lordship. That is in our region petition, I have already mentioned, Lordship.
Yeah.
Written statement are not considered, Lordship, in the file by the. Out of 25 recurring deposit amounts, Lordship, only one depositor was attended the oral inquiry and was examined, Lordship. None other than Lordship. The inquiry officer also should examine the contents of the written statement, but they could not do.
Yes.
No, no, no.
In order to accept it. That's all.
Our mention Lordship. Lordship, actually, Lordship, may I read my ground 10, Lordship. The learned tribunal failed, page 27, Lordship. Kindly look at page 27.
Page 10.
Page 10, no, page 27, Lordship, para 10.
Yeah.
Learned tribunal failed to appreciate the fact that during the oral inquiry, neither the inquiry authority nor the presenting officer could show non-credit by the petitioner. The then assistant superintendent of post offices who made preliminary inquiry and stood as prosecution witness number 3 on being asked by his defense assistant of the petitioner could not say about the amount, Lordship. Even the disciplinary authority could not show any details of misappropriation of rupees 2,20,000, Lordship.
Right.
And para ground 11 also, Lordship. The learned tribunal failed to appreciate the fact as stated in the appeal petition regarding passing of the order of the disciplinary authority without verifying the passbook, SU ledger, SU accounts books, and SU summary, and without examining of the individual depositor in regular hearing, Lordship. And they, on the examination, Lordship, they, in cross-examination, these witnesses clearly mentioned they are satisfied, Lordship. That is the ground of Annexure. Another gown annexure 11 Lordship, page 28 Lordship. That is reflected Lordship. Page 75 Lordship. Page 75. Question was put, Lordship,
Yes,
whether you have any allegation in the matter of your loss amount, that the answer the question, Lordship, I do not have any allegation and I am fully satisfied on receiving the back amount, Lordship. Lordship, kindly do the PWT's examination, Lordship, that is the Assistant Superintendent of Post Office, Lordship.
Yes.
Page 79, the category states that I do not remember the exact amount, but the amount was credited to the government account. Already, no loss has been done, Lordship. The same amount has been already credited, and they have taken more amount, Lordship. More amount, Lordship. 3,70,000 amount already deposited, Lordship. But they could not specify the specific amount. One time they have said the 2,20,000, one time 1,17,150, and FIR also speaks another amount, Lordship. Amount was also deposited before the charge was framed, Lordship, as per the instruction of the ASAP, Lordship.
that's all.
My humble submission, Lordship, the petitioner is also hailing from very poor economic background, Lordship.
What?
Poor strata for economic.
Poor
He has,
strata.
he's
So
already
he has
running
the
for
right
a
to- Since he
day-to-day
belongs to
bread.
Poor strata, this lower strata of the society, so he is entitled, he can very well embezzle that money.
No, Lordship, he has not given the proper training, Lordship, regarding
Training for
Lordship,
what?
regarding maintaining the account and other system, Lordship.
For training, so it is the, you are seeking a
Is the-
job and it is the now duty
It
of
is
the
only the
state,
Gramin Dak Sevak branch post
so
master,
that is also one of the excuses, since you are not properly trained and therefore now you feel embezzled it, that's all.
Lordship, I have already deposited the books as per instruction of the authority, Lordship.
That's all.
His running is also, he could not earn at this stage also to
That's all.
maintain his life,
That's all.
day-to-day life.
That's all.
Even Lordship,
Mr. Assistant Counsel, yes.
even Lordship,
Yeah, if you want to submit something, you may also submit. You are feeding him and now he is saying, directly you say to us.
even Lordship, I was acquitted, Lordship.
That is the only reason. You are acquitted when? When you were
No,
acquitted?
after the judgment was passed, Lordship.
Which year you were acquitted?
That is Annexure P, Lordship. That 20, Lordship, 2020, Lordship,
Now it is,
2024, Lordship.
so it's not a case that you were acquitted.
We have also filed a petition, Lordship, after that, Lordship.
Where?
That is Annexure Q, Lordship.
Next year,
Annexure Q, Lordship, page 131,
131.
Lordship, to the Director of Postal Services.
Okay, then what happened?
Thereafter, nothing has been done, Lordship.
That's why only.
That is pending,
You
Lordship.
waited up to, since 2021, you waited up to this date. And now suddenly you have now approached this court, na? Look here,
I have already made.
this writ petition is filed by the challenging the order dated 21/2/2019 passed by the Central Administrative Tribunal Guwahati Bench in OA number 91/2017. Quite impugned judgment dated 21/2/2019. The OA filed by the appellant against the order of removal against the order dated 28/7/2014 passed by the disciplinary authority removing the petitioner from service has been dismissed. It's stop. The facts, sense, the details of the case are that the petitioner while working as GDSB, what is this full form of this?
Gramin Dak Seva branch postmaster, Lordship.
Gramin Dak Seva
Branch postmaster.
Branch Postmaster. GDSB PM, Rangia, Tenali Branch, Post Office,
A small branch.
while working as so and so, branch. Was served with a memorandum of charge dated 14/6/2013, alleging inter alia that the petitioner has misappropriated the amount of ₹2,20,000 from different holders of SB/RD/RPLI accounts/policies on different dates. Full stop. Despite granting opportunities, the petitioner has not submitted his statement of defense. And thereafter the regular inquiry was conducted by the inquiry officer. Full stop. After thorough inquiry and deposition of witnesses with due cross-examination by the petitioner, the inquiry officer submitted his report. The disciplinary authority has ultimately passed the punishment order of removal of the petitioner from the services on 28/7/2014. The appeal preferred by the appellant against the order of the disciplinary authority has been dismissed on 25/3/2015, being agreed with the rejection, being agreed with the removal order as well as the order passed by the appellate authority. The petitioner has approached the Central Administrative Tribunal Guwahati bench by way of OA 91/2017, which came to be dismissed by the tribunal by impugned order dated 21/2019 by observing as under. Para number 10, 11, 14, 10, 11, 12. 10, 11, 12. Stop. The petitioner has not availed any remedy against the order passed by the tribunal till filing of this writ petition. In the writ petition, the petitioner, the petitioner has raised several grounds to impress upon this court that the inquiry that the disciplinary inquiry conducted against the disciplinary proceedings conducted against the petitioner suffers from various infirmities. Stop. We have taken into consideration the grounds raised in the writ petition challenging the impugned order, but found that the petitioner has failed to satisfy but found that the petitioner has failed to point out any procedural irregularity in the disciplinary proceedings, and has also failed to point out that any harsh punishment commensurate to the gravity of the offense has been inflicted upon him. Full stop. It appears that the reason for filing, one of the reasons of challenging the impugned order passed by the tribunal available to the petitioner is that he has been acquitted from the criminal charges leveled against him. He has been acquitted by the competent criminal court from the charges leveled against him in respect of misappropriation of respect of embezzlement of public money. Full stop. We are of the view that the acquittal of the petitioner acquittal of the petitioner from the criminal case cannot be can't be treated as a good ground for interfering with the order of the disciplinary authority or of the CAT, whereby the CAT has negated the challenge of the petitioner to the order of the removal passed by the disciplinary authority. Stop. It is also to be noticed that though the judgment, but it is also to be noticed that the petitioner has failed to explain the inappropriate delay, explain the delay satisfactorily in approaching this court while challenging the impugned judgment passed, impugned order passed by the CAT. The only reason supplied by the petitioner for causing delay in approaching this court is that he was mentally upset after passing of the order by the impugned order by the CAT, and he was in deep financial in deep financial crisis. It is also mentioned that there was a family dispute in the petitioner family relating to land, and for that reason also the petitioner could not approach this court immediately after passing of the impugned order. We don't find those reasons supplied by the petitioner are satisfactory to condone the delay in approaching this court. In view of the above discussion, we don't find any merit in this petition. The same is therefore dismissed.
Item 11.
Mr. Right, we are adding one more line here.
Lordship.
In between, we'll ask you to add. Otherwise also, before the disciplinary authority, the petitioner has admitted his guilt in so many words. And so many words. And else. While stating that on account of inevitable financial and household problems, he committed the offense. Full stop. As a matter of fact, before the disciplinary authority, the petitioner has given in writing that owing to inevitable financial hardship and household problem, he has embezzled the money of the public. Stop.
Right.
You have admitted before.
Mhm.
He could submit the number of charges and despite giving the he has not explained. In response to that, he has submitted his and being not that the inquiry was initiated.
Lordship, my humble submission before your Lordship, my representation is also pending, Lordship, before
Which
the order.
representation?
After acquittal, I have filed a representation.
Deemed to be rejected by this order.
Lordship.
Item 11.
Yes. Worship, I'm praying for further 1 week time, your worship. What happened, your worship, on the last meeting? Records were called for. I have received the request and it is admitted that the attendance register for the year 2020, 21, 21, 22, it went missing on 1/2/2023. That is not traceable.
In that office also,
From that office also.
missing.
Missing in the sense, your worship, that attendance registers are maintained by the cooperative societies.
No,
Lordship, now I am representing
the society.
Yes, I am representing the department, your lordship. Now that particular
Rule 80 says, what says rule 80 says?
80 I, your lordship.
Section 80 of rule.
Section 80 I, your lordship, of the Cooperative Societies Act.
Head of,
It has to be,
who is appearing for the cooperative society?
I am appearing for the department.
Who is appearing for the cooperative society?
No, it was run by a one-man. A departmental officer was managing the affairs of the society then.
Then,
But may I place it?
The head office, he was manning the head office.
lordship, at that point of time.
Where is that register? Because it says that in the head office, the register is to be
Yes, your
maintained.
lordship.
But there's another facet to it, if I may just add on. Till now, we have all been addressing the issue that admittedly 2 registers were missing for 2 years. So whether benefit of doubt can be given to the others or not. That is one part. Now there's quite another part. That if, and Lordship has knows, if a member of a cooperative society does not attend for any 2 years or attends for any 2 years, he is through. But if he does not attend for 3 consecutive years, which admittedly the position is, had they attended for 3 consecutive years, 2 out of the other 3, they would have been in. So they did not attend those 3 years. First 3 years, Milord. The last 2 years wasted.
How to ascertain that?
No, that is the only logical conclusion, Milord. Last out of the 5 years, 4 and 5, 4th and 5th year are missing. They say they attended here. Now, if they would have attended any 2 out of 1, 2, 3, they would have otherwise also sailed through. So they did not attend these 3. That is not even their case they attended. They could not have attended. Now, this is the specific case they attended the last 2. So if they do not, if a person does not attend 3 consecutive years meeting, what is the consequence?
The records of 3 meetings are available, and in those 3 meetings they
They're not. So what is the legal consequence?
though missing 2 years registered, it may be presumed that they attended that. Then also they are not qualified.
How? Page section, may I just invite members' attention? Section 23. Section 23, Milord. 23. One F, if I may read. May I read, Milord? The board may, by a resolution passed by 3/4 majority of directors present and voting at a meeting held for the purpose, terminate the membership of a member if he does not use the services of the cooperative society for a period of 3 years or does not attend 3 consecutive AGMs.
You mean to say that 3 consecutive meetings?
He's gone.
Means
He's attended
1, 2,
disqualification.
3. Admittedly, the first, second and third meeting.
They were not
have not attended.
So 23 one F comes in.
They have not attended.
They have not attended.
And only even if it is assumed that the 4th and 5th meeting. they have
Absolutely.
attended, then also. they
Then
are not
also
qualified.
disqualification comes.
That they are not.
Now we have to read it with the election rules. Rule 7 of the election rules. It's the same book, Milord. Rule 7. That's how I would like to address the matter. Rule 7 of the Assam Cooperative Society's election rules. If you're having the same book, it's 113.
113, no, it's not one.
So, Milord, I may just pass over my book 113. That's on the nomination part.
Yeah.
I'm not carrying the book though. May I read Rule 7?
Have you raised this point before the learned single?
No, I have developed the arguments as we go, as we argue by the day.
Now this one.
No, absolutely, Milord. I thought of what happens if the other 3. Then I came with the answer, Milord. That's not the question, it's a legal position, Milord. That's not the point.
We have to ascertain whether he has attended. You are for?
I am for the private.
Those persons.
You have to answer this.
Yes, my lord.
You have to answer this.
Yes, my lord.
That admittedly, if you have not attended the first 3 meetings,
Yes, Mr.
even though if it is assumed that you have attended the last 2 meetings, how you are eligible for that?
My lord, that is for membership, my lord. At the time of filing the nomination, no one was a member, my lord. The society was running under the one-man committee of the department, my lord. Department, my lord. The term was earlier, my lord, expired, my lord.
That is totally misplaced the way he's placing it. If it is run,
departmental officer was conducting the election, my lord.
Correct.
I have the notice, my lord.
Departmental officer conducted the election, but the persons
You file whatever the response.
absolutely.
That is.
Nominations can be filed only by members. They cannot be strangers filing nominations, Milord. That will be alien to the law.
Council appearing for so and so, which department you are appearing for?
Corporation department.
Cooperative department brings some more time to comply with it. To ascertain whether the record of the meetings is available in the head office of the cooperative society or not, or in the head office of the concerned cooperative society or not. Stop. List after 10 days. Interim order passed by this court shall remain in currency till next.
Would my lord be pleased to indicate briefly that it was raised that the consequences of not attending 3 meetings be admitted position? Very well, my lord. Obliged.
Item 13.
Time. May I plead your lordship? My learned counsel asked me, you will take time, but he's not here.
Who said? Yes.
Lordship, my learned counsel asked me, will take time, but I have not seen him.
You are challenging the rules that they have not given any preferential treatment to the experienced persons. This is what your case is.
Yes.
That means you are working as a public prosecutor from 2002, and now they have made some rules where the qualifications have been prescribed, which you are not having. Therefore, some preferential treatment should be given to you.
Yes.
These rules says that the age of retirement is 60 years.
Lordship, some time will be given, my senior.
You are 61 years, even though if preferential treatment, how this preferential treatment can be given to you after the age of retirement? 80.
Item 14.
Please, your lordship. Lordship, in this trial, I have to initiate inquiries into the illegalities committed by the Guwahati Municipal Corporation and its officials for illegally regularizing the services of 500 numbers of candidates. And Lordship have filed a complaint before the officer in charge, Police Station Vigilance and Anti-Corruption 17/3/2023. So after the Lordship, as per the affidavit filed by the respondent number 5. So there they have stated that page number office 8. That in regard to this, they have stated a preliminary inquiry was initiated at the Directorate of Vigilance and Anti-Corruption on 28/8/2023. That is after the issuance of notice by this court. So now, Lordship, the preliminary inquiry, Lordship, that has to be completed within a period of 90 days, Lordship, as per the office memorandum dated 19 April 2020. So now, Lordship, what is the status of whether any this report has been submitted to the government? So this is the office memorandum, Lordship, clause 3, where the preliminary inquiry has to be completed within 90 days.
2008.
It's not the last three lordship. The lordship directment fix the time for completion and
So what do you want?
lordship a time frame maybe quicker by this
No
inquiry.
time frame, once the already the matter is, this director of vigilance is inquiring into the matter.
But the preliminary inquiries will complete within 90 days, lordship, and whether they have submitted.
They might have completed it. And
The lordship
ultimately, this PIL, you are asking that these regularization of 500 workers, you have questioned it. Have you made those regular workers as a party here?
No, that's where I have not
Then-
made the workers.
How can be? Any order pass in this petition. Certainly, we have to record a prima facie satisfaction that this regularization is bad. Then what about those persons?
But lordship, I have still the officials who have conducted this, so mainly in the inquiry, the process, lordship, yes, lordship will fix the
That's
time
all?
to complete, yes, lordship.
The instant
To
PIL
complete the
petition
inquiry,
is
lordship
filed
make this fair.
by the petitioner. A direction, the respondent authority to take action against the officers of the Guwahati Municipal Corporation who were involved in regularizing the services of 500 contractual employees as regular mazdoor in the Guwahati Municipal Corporation. The reply to in the counter affidavit filed on behalf of the respondent.
Number 5.
It is stated that in the matter of regularization of 500 contractual employees as regular mazdoor in Guwahati Municipal Corporation, a preliminary inquiry wide government PE number 5 of 2023 has already been initiated at the Directorate of Vigilance and Anti-Corruption, and the same is in progress. Full stop. Since the progress, in view of the fact that the Director of Vigilance and Anti-Corruption is already inquiring into the allegation of regularization of 500 contractual employees as regular mazdoor in Guwahati Municipal Corporation. We are of the view that no further direction is required to be passed in this PIL petition. However, it is expected that the Director, Vigilance and Anti-Corruption of the state, Directorate of Vigilance and Anti-Corruption of the state shall made serious attempt, made every effort to complete the preliminary inquiry at the earliest.
Lordship, some time was please. At the time.
Time we can't, yes.
Item 16.
I'm actually sorry, my lord. Item 13, opposite party took time from consent from us that they will take time. So I was, item 13, opposite party took time, consent from us that they will take time. So I was, in another court, my junior was here.
So we have not passed any adverse order, we have simply adjourned it.
Ethics.
We have not passed any adverse order in the petition. We have simply adjourned it.
My junior could not understand.
Item 16 for hearing.
May I please, your lordships? Your lordship, with due earnestness, your lordship, I am praying for passing over the matter for the day, your lordship.
Yeah.
Much obliged, your lordship.
Item 18.
Yes.
My lord, the appellant already on the basis of the honorable court's order assess the valuation of the property.
That they done.
My lord, it is the government rate, my lord, but not market price, my lord.
What do you mean by market price and?
Market price, my lord, the government rate and market price is, my lord, separate. And that is also, my lord. It is a,
What was the court's order?
yes, my lord.
Upon considering review may their submission and call Mr. Talinga. This petition is called with the direction of to access the pay the damages caused to them and compensate the petitioner at the earliest. Alternatively, the petitioner providing a separate plot of land as per the settlement rules. The procedure shall be completed within 60 days. Yes. Is of 2021.
My lord.
The court has ordered in 2021.
I am for the respondent number one, my lord. I am the landowner, my lord.
What we are saying in favor of you, this court order was passed
Yes, my lord.
in the year 2021.
Yes, my lord.
3 years around, 3.5 years before. And they have offered you the plot. Which
That
you
plot-
refused, that it's not a suitable plot.
Yes, my lord.
Now they have compensated 24 lakhs. Keep this money, that's all.
My lord, it is, my lord, as per their calculation, my lord. My lord, page 109, my lord,
09.
at their affidavit and assessment, my lord.
Yes,
It is, my lord, one column, that is column 6, my lord. Additional compensation at the rate of 12%.
yes.
Yes, my lord. Additional compensation at the rate of 12% per annum to the total market value
Yeah.
at serial number 1. If it is, my lord, fixed by the authority, that is 24 lakhs. Upon that, my lord,
They are not the acquisition proceedings. They are the orders passed by the court. They are not the equity, 2013 acquisition proceedings are not there. Be happy with this money, that's all.
Lordship was in fact magnanimous enough, my lord, to direct the authorities, my lord, to calculate the compensation, my lord, with regard to the damage caused to his land. And that the my lord, calculation has been done within the parameters of the 2013 Act. Now that is, my lord, a value of rupees 12 lakhs. In addition, my lord, 100% solatium has been paid, my lord. It has now come to 24 lakhs.
Satisfied?
my lord, satisfied, my lord, just,
No.
just, my lord,
You want this money or not,
my lord.
then forgo all those claims, interest and all, nothing.
My lord, as because my lord, 20 years, my lord, my.
You want to contest the matter?
My lord. No,
Contest.
no, my lord, I am with the court, my lord, and
That's it. But by what time you will pay the money?
My lord, here, my lord, now the question is to arise, my lord, who is going to pay the money? Lordship will direct.
Between you and the state or whatever it may be, pay the money in how many days?
So, my lord, the respondent, with all respect, my lord, kindly, my lord, with all respect, my lord, the respondent number, my lord, 2, my lord, 2 and my lord, 4 may be directed, my lord. Because they have
Respondent number 2 and 4?
2 and 4, my lord, they have caused damage to the land.
Who are the?
Respondent number 2 is, my lord, Science and Technology Department, and 4 is, my lord, Sports and Youth Welfare Department.
Respondent number 2 is?
2 is, my lord, Science and Technology Department.
Okay.
Yes, my lord.
And respondent number 4?
Respondent number 4 is, my lord, Sports and Youth Welfare Department. Lordship may kindly appreciate, my lord, it was only because
And you are appearing for?
I am appearing for the appellant. Appellant number 1 is the Commissioner and Secretary Revenue Department. Appellant number 2 is the District Commissioner.
So why you have challenged this order?
Let's challenge this order, my lord, on that.
You were not supposed to pay the money.
No, my lord, direction was to us, my lord.
So then you have to pay the money, that's all, and you recover it from that science department or whatever it is.
No, my lord.
You recover it on your own.
No, my lord, the
We are not
budget,
concerned with that. You
no, my lord, the head of account
are from
budget,
the state government,
so that is
you
true,
are running
lordship.
the same thing.
No, lordship is correct.
Can't
But-
pass the buck on the other departments, that they seem that those are the responsible, you are not a private entity.
No, not
They
private.
belong to the
and-
state government.
Yeah.
Ultimately, if he gives and you gives, one and the same thing, ultimately money is going out of the pocket of the state government.
That
That
is-
was the problem in
No, lordship is absolutely, but only, my lord, for the proper, my lord, my lord, compliance of that order, I am making that submission.
in compliance. We are now pass the order. Make the compliance within a period of this period, otherwise you will be held responsible for that.
Lordship will kindly allow us, my lord, at least, my lord,
Yes, we pass it order at
8 weeks time, my lord. Kindly allow us 8 weeks time. I am so obliged.
Yes. Appeals. Preferred for on behalf of the applicant being agreed with the 20th of January 2021. Passed by the Amit Singhal and writ petition number 4309 of 2017. The Amit Singhal judges disposed the writ petition, taking into consideration the fact that the respondent land was encroached by the state agencies for implementation of project conversion and management of Depot Bean wetland in Assam. The landed single judges concluded that since the respondent's land was taken over by the state agencies, the petitioner, the respondent is entitled for damages caused, for the damages caused, or alternatively, the respondent can be compensated by providing a separate plot of land as per the settlement rules. The appellants have challenged the impugned order on various grounds, however, during the pendency of this writ appeal, as per the directions of this court, the appellants have offered a alternate land has offered alternate land to the respondent. However, the respondent was not agreeing for the alternate piece of land, as while claiming that the same is not suitable. Efforts have been made on behalf of the state to offer other alternate land to respondent, but the respondent has found that that alternate that alternate lengths are also not applicable for him. Taking into consideration above factors, above noted facts and circumstances, which this court by order dated 19/90/2024. Directed the pillar number 2, Deputy Commissioner Kanpur Metro, Guwahati to access the damages, to assess the damages caused to the property of the respondent number 1 and to submit the same before this court by way of filing additional affidavit. Pursuant to that, an additional affidavit is filed on behalf of the appellants, on behalf of the appellants, wherein it is mentioned that the where they have assessed the assess that the respondent number 1 is entitled to get compensation of rupees 24 lakh in lieu of as per the orders passed by this court, as per the orders passed by the learned single judge. White judgment dated 20th of January 2021. In response to, he said, the stand of the state government, the respondent has filed a counter affidavit and has claimed that he is also entitled for interest on the compensation amount as per the provisions of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. So, confronted with the situation that the land belonged to the respondent number 1 was not acquired by the state as per the provisions of the Act of 2013. The counsel for the petitioner has agreed that the respondent number would be satisfied if the amount assessed by the state government, if the total compensation assessed by the appellants to the tune of rupees 24 lakhs is paid to him. Looking to the above, in view of the above facts and circumstances of the case, we deem it appropriate to dispose of this writ appeal with the direction to the appellants to make the payment of compensation of rupees 24 lakhs to the respondent number 1 within a period of,
My lord, let it be 90 days, my lord, if it is
90 days.
90 days, because my lord, therefore, my lord, initially I had made that submission, we have to root the fund, my lord.
You have to
I have to, my lord, secure the fund, my lord, root the, my lord.
24 lakhs for this state government.
I have made the
Please,
submission.
don't make.
If it is otherwise not inconvenient, my lord, with all respect, my lord.
Within a period of 2 months from today. Within a period of 2 months from today. Order that's all in there.
Obliged. I'm so obliged.
IAS also disposed. All pending IAS are disposed.
Item number 1,
There is only one respondent. You are the respondent number one.
Yes.
What do you want?
My lord, file was, but I didn't get the clearance, but I spoke to the higher authority on whether, my lord. So will ensure to comply.
Yeah, what is your stand now?
Right.
What is your stand now?
Will ensure the compliance
When?
by today.
By today itself, you are going to comply with the
Right.
order.
My lord, in that.
Don't you understand the orders of the court? Don't you understand the orders of the court? In the earlier affidavit, you have attempted to test the merits of the case. We have specifically observed that this is not permitted. Again, today you have filed this affidavit. What is this? You are not reading the affidavit, or as per the advocate prepares the affidavit and you are filing it. What is this? After all, you are a senior and responsible officer. What attitude is? This shows that you are not interested in complying with the orders passed by this court. Or you are flouting the orders of the court. We don't want to invite this situation, but what else? What can we do now? Either your advocates are not properly instructed, or you are adamant that you are not going to comply with the order of the court. How many discontinuers are there?
Well, two contemners are there. Sorry, two petitioners are there. Oh, sorry.
How many contemners are there?
Two.
And how many appellants were there in the petition?
Two. No. In the contempt to main 8, there are other appellants because they have shared
How
the
many other appellants?
uh, 9.
Total 9.
9.
Out of these, who have filed this
File,
petition?
and when they were called to the office, they said that we'll give to only the relief to 2. Then that's why they have filed a intervener application also.
What about the others? Provide relief to all the appellants. Why to restricted it to 2 for 2 only? Their cases are similar. The orders are there.
Okay.
We'll posting it tomorrow. Please on record the complaints of.
Sure, ma'am.
Pursuant to. So in continuation of that, will be pursuant to the order passed of this court. Indeed. Pre-lunch session. The respondent of the part is permanently present before this court. Counsel Mr. R. Majumdar, preparing for the elementary education department, has informed this court. The respondent number 2 is on leave from 6/11/2024 to 8/11/2024. Therefore, he or she she is not able to remain present before this court pursuant to the direction. Pursuant to the direction, not able to remain present before this court. So, and a concern. The respondent number 1 present in person. Has assured this court that the order passed by this court dated
10/7/2018.
10/7/2018 in writ appeal number 304 of the 2014 shall be complied with in respect of all the appellants who have preferred the writ appeal number 304 of the 2014 today itself. Full stop. Taking note of the above assurance, we deem it appropriate with this matter tomorrow. The respondent number 1 shall produce the compliance report along with the additional affidavit while tendering apology for not complying the order passed by this court for so long. Mr. Kumar.
Yeah, bless, okay.
And please make the compliance in full letter and spirit. Don't keep it hanky panky that this part is complied with and this part is not complied. We don't want to invite this situation. And if the compliance order is there, you need not to remain present.
Item 19 for hearing.
Nothing, Lord. In this case, my lord, the petitioner, my lord, appellant as a my lord, constable of police lordship applied for the post of my lord, SI AB lordship, SI of police AB lordship. My lord, he, my lord, secured third position, my lord, with respect to the my lord, average marks lordship, in aggregate lordship. But by Gamson, rule of Gamson's lordship, he was deprived.
Yes.
Well, by rule of Gamson's, my lord, he was deprived, my lord, from selection lordship. Now, that was held by the learned single judge lordship. That part has not been challenged by the my lord respondents lordship. That is confirmed. It has attained the finality lordship. But I was not, my lord, given any, my lord, relief because, my lord, the last lowest scorer, my lord, was not party in the writ petition lordship. My lord, thereafter, after filing that, the writ petition was disposed of, my lord, on 28. My lord, it was disposed of on 28/10/2021. My lord, during pendency of the my lord case lordship, neither the state respondents, my lord, informed the court as regards the vacancy position. My lord, I was not having any knowledge lordship. Well, after disposal of the writ petition lordship,
You got an information through RTI
yes, lordship.
that 10 posts are vacant.
Yes, lordship. Then
Now the position is that those posts are also not vacant.
yes, lordship. That is during the pendency of the street appeal lordship, we informed my lord, and the honorable court by order dated, my lord, 17/10/2023 lordship directed to keep one post for my lord.
The selection is of the year.
My lord, that is of 2008 lordship. The writ petition was filed, my lord, immediately lordship. My lord, writ petition was filed.
2008.
My lord, since that he was not sitting idle lordship.
Then you'll ask for this appointment for an initial date, then all the benefits, promotion and all.
Yes, lordship.
Yes.
Promoted lordship. Some probably some has my lord has
That's the-
become my lord
that's the
ESP
problem.
lordship.
That's the
My
problem.
lord, now he remains as a constable lordship because of my lord illegally depriving my lord by gun sensing process lordship. My lord, now.
What happened in that, this, reference to the larger bank? Of K.
My lord, that, my lord, I have, my lord, verified lordship. I could not, my lord, find out that judgment lordship yet, lord. Probably that is not delivered, my lord, yet. My lord, before 10th of November, probably it will be delivered, lordship. Otherwise, I have not time. If, my lord, state correspondent have any knowledge, lordship.
Wait for that.
Yes, lord.
Wait for that.
Came on the street, like that means so.
This court. By order dated 17/10/2020. Therefore, the consideration is split of the awaiting outcome of the larger joint meeting. Pending consideration. Before the honorable court. Respect of ratio in the death of K. Manjushri versus date of Andhra Pradesh of the reported in 2008 3 SCC 51. It is informed that the decision of the larger bench is still awaited. History of the matter is this writ appeal after 10 weeks.
My lord, maybe before that, lordship. My lord, honorable chief justice,
16 weeks.
lord.
16 weeks or 10 weeks? Deferring this matter for 16 weeks or 10 weeks?
My lord. After 10 voting. My lord, maybe before 10 weeks, lordship. Before 10 weeks, lordship.
It's okay.
All chief justice is going on, my lord.
Item 23.
How like that?
Always.
How like that?
Who's for the other side?
My lord, other side.
Nobody.
My lord, the only issue is, my lord, whether the appellant as a, my lord, receiver of services can shift the liability to the service provider. My lord, the learned single judge has held that the appellant can, provided there is a provision in the contract. But my lord, with respect, my lord, learned single judge missed the particular provisions of the contract. Which I'll just take your lordship to that provision, my lord. My lord will come to page 105. The lordship got it, my lord. Page 105 of the appeal.
Yes.
First, my lord, clause 36 says, service tax or other taxes on material in respect of the contract shall be payable with the contractor, and food corporation shall not entertain any claim whatsoever in this respect. Now, my lord, kindly see 36A. The first line says, all tender rates shall be inclusive all taxes and levies payable under respective statutes. Now, my lord, can keep out the last line, it says, last line, my lord, service tax will be governed as per circular number 09 of 2012. That, my lord, will kindly will find at page 181. 181, the lordship kindly come. 181 is the circular, and relevant is at page 184. Page 184. Lordship will come to clause 5 of that, my lord, which says, lordship got it, my lord. Clause 5, it says, where the contract has been awarded inclusive of all taxes, service tax, if any, payable by the receiver need to be deducted from the bills, and the amount so deducted should be remitted to the service tax authority. Where the service tax is awarded exclusive of taxes, service tax liability is to be borne by the FCA. Wherever the contract is silent on this point, the matter may be examined by the regional office. So, my lord, this clause 36A says it's inclusive of taxes. Therefore, my lord, as per the circular, my lord, this what we did, my lord, we have deducted this and deposited already to the state authorities. And my lord, this circular, in fact, my lord, escaped the notice of the, my lord, single judge, my lord. State authorities are not made party in the writ petition, my lord. We have already deposited the entire amount to the. The other issue has been decided in our favor. Supposing the total amount of the bill is rupees 100, my lord.
two points were formulated, A and B. A was in your favor.
Lordship, that was,
B,
we only said.
but here the learned single judge has taken into consideration a notification dated 20th
That
of
is the
June
tax
2012.
lordship, but not this one. This is the relevant notification, Lord, which forms part of the contract.
Where is that notification? 20th of June 2012?
That is the, Lord, 20th of June. Uh, uh, Hmm? Oh, my lord, it is here at page 164. That says 50-50, my lord.
Where is that?
Page 164 and relevant, my lord, at page 166.
Subject to services provided or likely to be provided in
Execution of works contract,
division work contract, 50/50.
50-50. That is there, no? That is by the taxing authority.
But this notification you are referring at page 181 is the same notification reference of which made in this 36A.
Yes, Lord.
No, it's not.
Yes, Lordship will kindly see.
Service tax will be governed as per circular 9/2010 of excise taxation cell. It is 99, 2011, 12.
But circular number is, my lord,
9/2000.
9 is present. This is the number of the circular.
This line service tax will be governed by the as per circular 9/2 excise taxation cell is scored out or
This is the circular, my lord. In fact, what happened?
no. The original in the original contract, in fact, is photocopy, it appears that is scored out, it is cutted. These lines are cutted.
Original, my lord. Service tax will be governed as per circular number 9 of 2012 FCA taxation cell. This is taxation cell. At the top, my lord, will find taxation cell. Last says the service tax will be governed as per circular number 9 of FCA taxation cell.
Here in photocopy, it's scored.
Oh, but my lord. Oh, my lord, but that's not. In both your lordship's copies, my lord, is like this, but the copy, the 9, original copy. Na? Yes, okay, 9. One, 8 on this one. Oh, my lord, this is my underline. My lord, come to page 181.
So who has signed it? His initials are of whom?
My lord, this, I think, this is, huh? No, my lord, I think, this is a copy of the petitioner's copy, my lord. In fact, lordship original is. No, excuse me. Okay, sign what's it? Parts of it. The card certificate is there. 105, it is the petitioner copy. Huh? It red petitioner copy. My lord, this is a copy from petitioner's copy. Oh, यहाँ पर तो नहीं. Original underline. But in my copy, it is not there, my lord. It is underlined by not by us. But it is.
Both the copies, it is same.
But आपका उनका फाइल पड़ा था अंडरलाइन करते हुए
Original application. I can produce the original, my lord. That's it. Okay, I'll put it in. 105. 105. Hmm. Look at that.
Produce this original.
That's better, my lord, because in my copy it is not there. How then?
In
No, that's a
both the
lot.
copies, it is.
No, definitely, my lord. We'll have to produce the copy, my lord. Otherwise, my lord. Does it fit to the Sleep.
When
My lord, post it after. If it is not here, my lord, 10 days, my lord, because we may bring it from that quarter.
then it concept for the place for and practice time to verify whether the contract executed with the FCI and the response. Particularly clause 36A. Is verified that the service tax will be governed as per circular number 9 of the 2012 of FCI taxation cell. Agreement NIT part of clause 36 of the NIT. NIT. Then the place of that, if possible, the concept of the produce original copy of the NIT and the contract agreement
That's better.
executed between the FCI and the respondent by the next day.
No, no.
19. 19.
1911.
1911. Yes.
Item 26.
Not responded. Lordship, here 504 and rule 9(1) of the CCS leave rules. That is absolutely clear, Lordship, regarding that engagement of leave of a employee who is dismissed from service, Lordship. But learned CAT have not entered to that, and the judgment and order is that 504 has no relevancy. And given weight is only to 503 and 542, Lordship.
Lordship, before the tribunal, I relied upon two rule provisions, that is 524 2B, that your Lordship will find at page 133 in my affidavit in opposition, 133. I am reading it, Lordship. 524B. When a railway servant is removed or dismissed from service or dies while in service.
524?
524 1B, 2B.
Yeah.
Below. When a railway servant is removed or dismissed from service or dies while in service, credit of earned leave shall be allowed at the rate of 2.5 days per completed calendar month up to the end of the calendar month preceding the calendar month in which he is removed or dismissed from service or dies in service. So this is completely in my favor, Lordship. Then, Lordship,
Read this. Number 2, subject to the provisions of Rule 503, 541, as well as this rule. The maximum leave on average may be granted as it can be on a calculation of leave average.
that is 523. I am relying on 524B. May I read it again, Lordship? When a railway servant is removed or dismissed from service or dies while in service, credit of earned leave shall be allowed at the rate of 2.5 days per completed calendar month up to the end of the calendar month preceding the calendar month in which he is removed or dismissed from service or dies in service. Then there is
504 then.
Yes. Lordship, I am relying on another provision also.
What about how will you
504.
this 504?
504, yes, Lordship. I'm reading it, then I shall interpret it, Lordship. 504, effect of dismissal, removal, or resignation on leave or at credit. Except as provided in Rule 541 and this rule, any claim to leave to the credit of a railway servant who is dismissed or removed or who resigns from railway servant ceases from the date of such dismissal or removal or resignation. Now, Lordship, this discusses about, according to my submission, Lordship, what I would like to submit is that after his dismissal, no leave will be credited to his account. It stops then and there, and he will not be entitled to any leave thereafter. Suppose he goes on leave on dismissal today. If he is dismissed today, he cannot say that I will claim for another period of 5 to 6 days, and thereafter my dismissal will come into effect.
Any claim to leave to the credit of railway servant.
Yes. Yes. No more leave.
Credit.
No more leave will be credited to his leave account.
Any claim to the leave to the credit of the railway servant.
My submission, it will not be credited any further. Then Lordship, and then Lordship 524 2B is absolutely clear, Lordship, 524 2B. Then it has been further clarified at page 136, 550 B2. Lordship may have a look at 550 B2, page 136. I'm reading it. Where the services of a railway servant are terminated by notice or by payment of pay and allowances in lieu of notice. 550 B2, B12, B12.
Yeah.
Where the services of a railway servant are terminated by notice or by payment of pay and allowances in lieu of notice or otherwise in accordance with the terms and condition of his appointment. I am covered by this. Otherwise in accordance with the terms and condition of his appointment. He is a regular employee. His termination is as per the railway servant discipline and appeal rules. That is according to terms and conditions of his
by notice or payment of in lieu of notice. Otherwise, in according to
terms and conditions.
May be granted to whom or to the authority competent to grant. This is not in relation to dismissal.
He is terminated in accordance with the terms and conditions of his appointment.
No, not terms and conditions. What do you mean by terms and conditions?
Lordship, he is a regular employee.
Terms and conditions are the what? Disciplinary proceedings were initiated and then he was terminated.
Yes, Lordship. So,
Doesn't include this terms and conditions, suppose it's a tenure appointment or something else. That's all.
it says or otherwise. If it is by terminated by notice or by payment in lieu of notice or otherwise in accordance, I'm a regular employee. I'm subjected to a disciplinary proceedings. And Lordship, 524 2B is clear, Lordship. 524 2B. 524B, Lordship, again I'm reading when a railway.
524B was not placed before the CAT. Even in their petition also that is.
So maybe, but if it is relevant, we can consider it's a statutory provision map.
When a railway servant is removed or dismissed from service or dies while in service, credit of earned leave shall be allowed at the rate of 2.5 days per completed calendar month up to the end of the calendar month preceding the calendar month. Then, Lordship, I shall also rely on the Supreme Court judgment, para 28. I think it is already there with your Lordship. I'm again furnishing. Yes, Lordship. State of Rajasthan versus OP Gupta, para
It is
28.
settled that when the financial rules framed by the government, such as pension rules, are, I think, capable of more interpreters than one, the court should lean towards the interpretation which goes in favor of the employee.
It may say about pension rules, but my submission is that, Lordship, financial rules such as pension rules. Financial rule is the genus and pension rule is the species, Lordship. Like pension rules, leave
Are
rule is also
capable of more interpretations than one.
one.
And if we come to the conclusion that there's only this one interpretation can be made, then
Lordship is the authority to interpret all the laws available, provision of law. And Lordship, one more submission. Lordship, another submission is that, Lordship, the penalty order is absolutely clear. Penalty order is at page 45, operating portion. Penalty order is at page 45, operative portion. It is absolutely clear. Page 45, Lordship may have a look at page 45 of the writ petition. Dismissal from service without any compassionate allowance, that is pension and gratuity both. It does not speak about anything else. So doctrine principle of casus omissus is absolutely applicable here, Lordship. It has been during during pendency of the OA, Lordship, they have released the GIS money and the PF money. And because there was no order as such for withdrawal or withholding of any all these. So as on today also there is no order for.
what they are saying that by the virtue of 504, that has ceased it.
Then 524 is in my favor. And moreover, Lordship, another aspect is there, Lordship. As on today, Lordship, OA before the tribunal against the dismissal order is pending. So if
So better wait for that. That why you have approached them for that.
man is Lordship actually without any financial support, he is facing difficulty to pursue
Suppose
case
you
also.
got this gratuity and all. John,
Lordship, my submission is that 524 is in my favor, Lordship.
consider it. It's not,
And Lordship, another submission is that Lordship, any decision shall not prejudice the outcome of that particular OA because
can't be, can't be.
if dismissal is gone, Lordship, anyway I am entitled to leave encashment.
Certainly, this, whatever the order, that will not going to affect the merit of that OA, wherein you have challenged that dismissal order.
Regarding leave encashment also, Lordship, because dismissal is gone. Anyway, Lordship, I have filed, Lordship, I have prepared one written argument also that can be taken into consideration, Lordship.
What is that?
Oh.